We'll take like a 5-minute break after TIAA is done, and you can pick up your lunches and then come back and we're going to just right on talking to you. So again, welcome, and I'm going to introduce Suzanne Spunzel. There's 3 Sues, so try to keep it straight. I'm trying. Suzanne Spunzel from TIAA.
Thanks, Emily. It's the morning for the Suzanne's. I'm Sue Spunzo with TIAA-CREF. I work with associations, and I've been with the company for 17 years. I've been working with independent schools in particular for the last 7 years. So thank you for having us today. What we wanted to talk to you about was wanted to give you an update on what's available for everyone's plans with TIAA-CREF, let you know what's new, make sure you know all the services we provide in case you haven't heard from us recently. I think it's been over a year since we've been here to talk about things. We wanted to talk about plan economics, just to explain a little bit to you how the plans are priced, how it works, and discuss the changes that are happening to CREF this coming year, and fill you in on what your employees would be hearing from us, and make sure you're aware of that and answer any questions you might have. I'd like to introduce our 2 speakers today. I have Ed Whitlock is here. He's a new relationship manager in the Philly area. He's located in Philadelphia, in Philly, right? And he's joined TIAA-CREF last July. And with Ed, we have Robert Cassell. Robert's been here a long time with TIAA-CREF, 28 years. Right now, he is the director managing the relationship managers in the Central States, including Pennsylvania. So Ed, I'd like to turn it to you.
Good morning, everyone. Let me see if I can just make sure we're set to go. Okay, we can went that way. That's fine. Well, thank you for inviting Robert and I to present this morning. We greatly appreciate the opportunity to talk to you. Again, my name is Ed Whitlock. I was brought on to TIAA-CREF in July of this year, so I'm new to the organization, but not new to the industry. I've been doing this roughly 20 years. If you can't tell by the bald head, I've been doing this for quite a while. So we do appreciate the opportunity to talk. Robert and I are going to talk a little bit about services that TIAA-CREF has to provide, and then Robert will be, I'll invite Robert up here in a few minutes to talk a little bit about plan economics, pricing, that sort of thing, and then some CREF portfolio changes. Feel free to interject an opinion or ask a question as we go through the presentation. I'd much rather have this be a dialogue versus me just standing here and presenting to you. So if you have questions as we go through the presentation, please feel free to ask. Okay, so just a little bit about how we're committed to helping you as the plan sponsor and your employees. And we sort of have a 4-prong approach, right? We want to do it through plan design. So whether that's creating an alternative matching contribution formula or going with a safe harbor plan design, we want to make sure that the plan that you're offering to your participants helps maximize the benefit. Investment solutions, right? So making sure that we have the appropriate type of products in place for participants to invest in. Employee engagement, that's a huge, huge issue. As I've met with some of you folks, I see some friendly faces in the crowd. Consultation and participant advice has been a hot topic with everyone I've met so far. So something we obviously want to address. And then plan management, that's really just making sure that from an administrative standpoint, we are operating as efficiently and as affordably as possible. So what are some of the services? So let's talk a little bit about plan administration. We have online enrollment, which obviously makes it easy for the participants to get into the plan. Hardship determination services, for example. So when a participant has a situation that could be life-altering, foreclosure, a death in the family, want to pay for higher education, we can determine the amount of hardship for the participant, make sure they can get that. And Roth 401k, some of the folks in this room, I've had this conversation with a number of you, haven't we, Cindy? Talking about implementing Roth. So that's another way for participants to diversify their tax liability. So it's a nice feature to add to the plan if you haven't considered doing that already. Employee services, participant plan-specific changes. You want to change the portfolio in some way. If you have a fund change or some other communication, we can help with that. Again, we talked a little bit about financial education seminars, whether those are one-on-one consultations or you want to have someone come in and talk about debt consolidation or their personal finances. We can do those types of seminars. Individual advisory services. So if you have some folks that require specific needs like estate planning or more complex financial issues, they have the ability to work with one of our wealth management specialists. They can hire them and work with some of those complex financial issues. And of course, online planning tools. So we'll talk a little bit about that in the next couple of slides. Participants have the ability to go online and use a number of resources there. Sponsor services, the annual plan review. So as your relationship manager, again, I think Suzanne pointed this out, I'm the regional relationship manager for the Philadelphia area. So for the most part, my clients fall in between anywhere between 10 million and 50 million in assets, depending upon where you may fall. I'm charged with meeting with the plan sponsors and going over the plan demographics, the plan financials, all the fun administrative stuff, making sure that the plan is running as efficiently as possible, so making sure that we do that. Plan financial reporting package and audit support. We obviously want to make sure that those are falling for ERISA purposes. We make sure that you're up to date and current with that information. And fee disclosure services. So that's coming up, right? We have some important fee disclosure information coming up. There's a fee disclosure assist tool on Plan Focus, which is the plan sponsor website. And we provide you some support there with some online information that you're able to disseminate to your employees. So in investment product services, I think we have the range pretty covered, right? We offer annuity products. For those of you who are not familiar, we also offer open architecture. So if you're interested in adding mutual funds to the portfolio that are not non-proprietary investments, right? So they're not TIAA-CREF investments, we have the ability now to do that. So you're able to offer additional investment to your employees like a Vanguard, like a T. Rowe, right? So it's just another way that TIAA-CREF is providing additional investment options to the employees. Any questions so far as we go through? Pretty straightforward. So it's a really, I mentioned this, a two-pronged approach, right? We want to make sure that we're addressing participant needs, so we give them a number of different resources on the web that they can use. The Financial 360, where they can import financial information and have an overall financial perspective of what their finances look like. Again, we allow online enrollment if participants want to take advantage of that. Retirement income planner, so they can sort of project out what kind of income they'll need post-retirement. And then online advice, so it helps them asset allocate, right? Go online, take a look at where their investments are invested, and make investment decisions based on how their portfolio looks. And then from the plan sponsor's perspective, we offer Plan Focus, right? That's the online tool that plan sponsors have, and there is a wealth of information out on this resource. There's participant level data, plan level data. There are compliance, as a compliance tab that helps you with any sort of compliance issues you may have, you need to address. And again, there's audit information out there, so all the information that you would need to efficiently run your plan is all located on Plan Focus. So essentially, it really comes down to three basic steps. Step number one is to make sure that administratively we're operating the plan as efficiently as possible, right? So that's sitting down, looking at the plan rules, looking at the plan document, making sure all that information is accurate. So when the participants call and request a transaction, there's no issues with that. So we want to make sure we do all the basic stuff right, making sure that you're in compliance. Step number two, right, this is where I have a real responsibility in making sure that I'm becoming your trusted advisor, bringing you up to date on compliance issues, making sure that you're up to date on regulatory issues, making sure your participants are taking advantage of all the resources that we have available to them, whether it's one-on-one consultation, whether we're doing group meetings, or whether they're using the online resources, right? So we have a way of measuring all that information. When I meet with you on an annual basis at least, we'll review all that information to make sure that the participants are truly engaged with TIAA-CREF. We're looking for a partnership. We're not looking to become a vendor, right? We want to make sure that we partner with you and your employees to maximize the benefit. And then at the end of the day, optimizing your plan design and usage, that's sort of where all this stuff comes together. Right, so we've taken care of all the basic information, the rules, the regulations, all the plan documents, administrative stuff. And then we have the compliance stuff that we need to follow to make sure that we're in compliance with ERISA and DOL and the IRS and all those guys, and making sure that's all addressed. And then everything sort of comes together, so we're making sure that we maximize the benefit for the employee. The next topic is, which will lead into Robert's discussion on plan economics, is 408B2 fee disclosure regulations. This was implemented in 2012, and it has been, in my opinion, a very good thing for both plan sponsors and participants, right? This is all about fee transparency and making sure you as the plan sponsor are aware of what you're paying in fees and making sure the participants are aware of what they're paying in fees. You know, at the end of the day, it's really about value proposition, right? You know, what are you paying for, and are you getting what you're paying for, right? So that's really what fee disclosure is all about. From a plan sponsor's perspective, you have a fiduciary responsibility to make sure that you're holding TA Crest to the fire, right, and making sure that we're keeping our fees in line, everything's in check. And then we have a responsibility to you to make sure you have that information and it's accurate. And then as a fiduciary, you need to make sure that the participants are paying reasonable fees as well. So that's what fee disclosure really is all about. Yes, it's extra work, but it does certainly help making sure that you as a plan sponsor are meeting your obligations, and so is TA Crest. That's going to lead me to the next topic, which is plan economics. So I'm going to invite Robert up here to talk about that. And Robert, that's right. Yep. I just need to do that.
The little button. I see 26 buttons. Again, my name is Robert Casella, and I'm happy to be here. This is the second time I've actually met with this group, so thank you for welcoming me back. I'm going to try to wrap up my comments relatively quickly. I do have a lot of slides to go through. I do want to open up the floor for questions. I also want to mention in the back of the room with Sue, there's a printout of the piece that we have available online. It's called Deciding What is Reasonable, Assessing Fees Using Values and Outcomes. So oftentimes a lot of plan sponsors, a lot of participants are only focused on the fees, and what we encourage everyone to do is take a look at the value of the fee. You know, what is the outcome that you're generating for your participants, and what is the value of the services that you're receiving. Many of you are receiving services not just from TI-CREF, but from other entities. It could be a TPA, an auditor, it could be an investment consultant. So there are a lot of service providers that work with your plan, and you have to take a look at the value that all of us are providing to you and your participants. And this is a good way of starting that analysis and that view. So a button, Ed. That one didn't work. Neither did that one. Ed. Enter. The arrow. Got it. All right. Yeah. So there's a change coming on. We've announced this to all plan sponsors in the pricing of CREF, and we're going to get to that in a little bit. What I want to talk about is what has developed over the last few years. It really started with fee disclosure, where plan sponsors were looking to provide specific services tailored to the needs of their participants as they understood them, and fee disclosure made it very apparent to everybody what everyone was paying. What happened is, as a result of this, plan sponsors were asking us to, in effect, justify our fees and change the way our fees are actually charged in the accounts. So this evolution led us to last year going to the SEC and asking for an exemption to some of the laws that cover annuities to apply the same laws, the same rules that apply to mutual funds that they've been using for a decade or more. And that's to create different share classes within CREF in order to charge fees that are appropriate for the services that are being provided to different segments of clients. So I think it's a great enhancement in what we're able to do, because we're able to generate fees off of the plans to provide the services that you want to contract for. And it equalizes the playing field between what mutual funds are able to do with actually what we're able to do with our own mutual funds, what the industry is able to do with FAIRs, and do the same thing on the annuity side. So we went to our board and asked the board for permission to do this after the SEC granted their the exemptions that were necessary, and the board said it was a good idea. because what we were doing was we were responding to the needs of our clients. Our clients were asking for different types of services in each one of their plans, and there had to be a way to generate the income out of the plans to pay for those services. So this was very much something that was driven by our needs, by clients' needs, and our desire to be able to meet those needs. So we're in the process right now of rolling that out. There are communications that are going to you as plan sponsors. There will be communications, fee disclosure that I just mentioned that will be triggered by you to go out to your participants, and then the change takes full effect in May of next year, or May of this year. So you know, I know there are a lot of words up there, but that's essentially what's up here, and we can talk a little bit more about that as we get into the questions. Just very quickly, there are three types of investment or expenses that you look at when you're taking a look at your plan. The most common one that people know is the expense ratio of the funds that you're using. Sometimes there are plan level administrative fees, the second box on the top, that are built into the funds as well. Sometimes they're not. It depends upon the selections that you make as a fiduciary on your plan. And then there are plan level service fees as well. So I'm not going to get into what all of these expenses are for, but I would say that they go to different organizations that you work with as a plan fiduciary in order to, you know, and in developing the services that you're providing to your employees. So it's not just TI-CREF, it's other organizations that you would work with as well. In the essence of time, I'm not going to go through this in very explicit detail, but I do want to mention the second bullet point, which, by the way, I'm using explicit twice in two sentences. The explicit fees that are charged that are billed to your participants. This is often something that we hear from you as a plan sponsor that you want to limit or eliminate, and the change in CREF is actually going to enable you to generate more income out of the plan to offset those fees. So if you do have fees that are explicitly charged to participants, you're going to have more options to offset those fees. And I also want to mention it's fully within your power as a fiduciary to determine whether or not you want the fees to be explicit, that is, that they show up as a line item on your participants' accounts, on their quarterly statements. They receive notifications from us that the fees are being deducted. You choose whether or not you want to do that, or whether you want the fees to be implicit asset-based fees built into the program itself. So you would either increase or decrease the amount of revenue that's being created by the plan in order to offset fully the cost of the program, or only partially. So that's a plan administration question, a fiduciary question that you could answer. This, I think, is very important. This gets to the reason for the change in pricing for CREF. What we had in the past was, you know, plans. If you take a look at it on the left, you have the smaller plans going up to the larger plans. And then you have, in terms of the revenue requirement, the cost of the program. And on the bottom, you have a smaller plan to a larger plan. And what you generally see in the industry, and this is for all record keepers, the smaller the plan and the smaller the average account balance is, the higher the price is. And as you move further to the right, it becomes less expensive for a record keeper to provide the services to participants. So this is sort of a downward sloping line that would represent the costs of programs there, and the costs are in percentage terms. So the percentage cost for a smaller plan is generally higher than the percentage cost for a larger plan. What we do is we offer the ability to add additional services to your plan. So this is the base record keeping service. You might work with an investment consultant and need to build that cost into the program. You might want us to provide 5500 support, non-discrimination testing. You know, there are a whole host of services that you can add to the basic package of services that we provide, which are services to your employees and to you as a plan sponsor. And that might move the cost above that line. But again, it's based upon the individual decisions that you're making as a fiduciary for the plan. And what we had prior to the change in CREF was one price fits all. So we charged the same amount across the entire spectrum, whether you had a $500,000 plan or a $500 million plan. Fee disclosure came around, and the larger plans were saying, "Wait a minute, we're generating excess revenues here." Fee disclosure shows that to us. We no longer want to be part of this TI-CREF system. So this was great decades ago when it was one system, when it was TI-CREF, and everybody was supporting one another. The larger plans are saying, "You know what? You give us that money back." And as a result of that, this subsidy that was occurring at the smaller end of the business no longer was there. So what happened was, everybody's trying to design their plans. The smaller clients want to have the same services that are being provided to the larger clients, and it just became something that was not economically possible to do anymore because of the way CREF was structured. So when we came back and went to the board, we said, let's do this. Let's align the cost or the expenses with the plans, with CREF, with the cost of delivering the services to participants the best that we can. And what we did is we came out with this sort of stair-step process where the costs are different depending upon the different segments that you might be in based upon the assets that are in CREF. So what we're trying to do is, what we're absolutely doing, CREF is still a not-for-profit organization. It still operates on an at-cost basis. What we simply have done is align the revenue that's being produced out of the plan, out of the CREF accounts, with the costs associated with the services that we're providing to clients. So, it's something that I think is going to give you a lot more flexibility as it takes hold and improve the economics of your plan. There are 3 share classes. I just want to talk about a little bit about the R1, which is for $20 million or less in CREF assets. And just to give you an idea of the cost increases, it's right now that account is at 46.5 basis points, and it's going up to 68 basis points. Let me put that into perspective for you. Right now, for this account is the global equities account. Right now, 99% of all investments in that category, according to Morningstar, are more expensive than that particular CREF account. So after the change, 96% of the funds in that category are going to be more expensive than CREF. So it's still an extraordinary value when you take a look at it just from where it sits within the industry. And because it's giving you some more flexibility, we think it's going to be a positive change overall. In addition, I mentioned how the plan is going to, or the revenue generation out of the plan is going to be stronger. So as we're increasing expenses, we're also increasing the amount of money that comes back to you as a plan sponsor to offset the expenses of running your program. It's moving from 24 basis points to 35 basis points. So again, you might have situations where you're working with a consultant that's, that you need to pay, write a check directly to, and your plan does not generate enough income out of the program to offset that cost. This may, and I say may because everything is based on the individual economics of your plan, this may produce that extra income with that additional 11 basis points to help assist with paying that bill. And in order to figure that out, you have to work with Ed or with your relationship manager. So that just gives you an idea of how this would work. The R2 share class, some of you might have more than $20 million in CREF. There are some differences there. The amount of revenue the plan is going to produce is a little bit lower. It's 20 basis points instead of 24. So what's going to change? You're going to have higher expenses. There's going to be an increase in the amount of offset of the revenue that the plan produces for you to help offset the costs. What's not going to change is we're still operating on an at-cost basis within each of those segments. Our investment strategies remain unchanged. So it's not a change in the way we manage money. It's a change in the way we've structured the account legally in order to help you, enable you or give you the flexibility to provide the services that you need and want for your participants, and also on a regulatory basis. This is just a chart that shows you the other CREF accounts. 8 out of 9 of them are still going to be below the median cost in the industry relative to Morningstar. The one outlier is the money market account, which is more expensive than the average fund or the average money market fund. But I think you can take a lot of comfort in the fact that the expenses are still extraordinarily competitive with the industry as a whole, and we're increasing the amount of revenue that's being produced to give you additional flexibilities with your decisions on the plan. So just a little bit more about the timing. As I mentioned, we've already sent out the notifications to you. There's a notice that's going to have to go out to employees. One thing that's going to happen is that you'll have some employees that are in multiple share classes based on their prior employers. Some questions might come up about that. You can just direct them to us to respond to those questions. But the participants will receive notices that there's going to be a change in CREF. The prospectus is going to change in April. And in the first quarterly statement in July, they're actually going to see a change in the share classes. They're going to be moving to R1, R2, or R3, depending upon their employer's plans. So that's it for me for now. I went through a ton of information in about 15 minutes. I didn't mean to rush. Well, I did mean to rush. I wanted to get the information out to you. We've been communicating about this for some time, and I wanted us to have enough time to answer any questions that you might have about the changing CREF plan economics or the services that we're providing. So if I could ask Ed to come back up here, we'll open up the floor for about 15, 20 minutes of questions. Or
none. I can sit back down.
Yes. I'm sorry? Okay. Yeah. Thank you. The question is what's changing with R2? So R2 share classes are right in the middle, and there's very little change in the actual expense ratio itself, but the revenue that is being created, the revenue offset is going from 24 down to 20. So there's a slight decrease in the amount of revenue that's being created. The problem and it's not perfect, again, because the economics of every plan are different, but the issue that we were trying to address for our clients there is our clients are coming to us saying there's too much revenue being created here. We can't, you're charging us too much, you're giving us this money back now, and we're crediting it back to participant accounts, or we just can't spend the excess that's there. And again, it might not be in every case. So what we did there is we lowered the expense, the reimbursement, the plan services expense reimbursement a little bit. But if you're in that situation, I'd encourage you to talk to us, and we'll figure out what the situation is for your plan. There's another. Yeah. Sue? I was either very clear and everyone understood everything perfectly, or I lost everyone.
The communication about this to participants, how should or would that be?
Go ahead.
I asked you up here to answer that.
Thanks, I appreciate that. What was the question was communication to the participants, how and when that
Yeah, the fee disclosure communications.
So there's
Where are you going? The question is, what are the specifics behind the participant communications for the fee disclosures? How does that actually happen?
Yeah. there is on the fee disclosure assist tool. Is everyone familiar with that when I mentioned that to you? All right, so there'll be information out on the fee disclosure tool that you'll be responsible for going out and completing in order for CREF to communicate the fee disclosure, communicate the information to the participants, much like you do sort of towards the end of the summer with a regular fee disclosure information. You go in, there's a spreadsheet out there, the value, and you confirm it all reads correctly. That's the same process basically for the CREF communication piece as well. So there's information out there, should be out there now, that speaks to this. If you go out onto the fee disclosure tool and you don't see what you're looking for, you're obviously welcome to give me a call directly, and we'll get you pointed in the right direction to make sure we address what you need.
So you're not pushing something to us, not that to do this. Always possible to show them.
No, are we pushing information out to plan sponsors about what TICREF is doing and what you're doing as the plan administrator, what you need to be doing? Yeah, we are. Information went out. It's something that we do think you need to. If it doesn't ring a bell right now, we think when you go back to the office, you should take a look at what's necessary. Essentially, we need a list of your employees uploaded into our system. That's what we need. And current eligible employees. So it wouldn't be all employees. It would be employees that are eligible to participate in the plan. And I think it might even be finer than that, because we, of course, know who your participants are. I think you just need to augment that data with the eligible non-participants, and then you would trigger us. You would trigger on the system the mailing. Once you have that data complete, we'll get the information out to your employees. So it's all eligible participants that need to receive it, and we, so you just need to complete the data set for us.
Yeah, and again, if you do struggle or can't find the information that you're looking for, please don't hesitate to give me a call, and we'll get you pointed in the right direction. We'll make sure it all gets squared away. Yes.
I think it's either or.
Yes, whatever.
Home? Or is it home? Thanks.
I'm trying to think it off the top of my head. I should know it. I don't know if Sue asked or not.
What's that? All right, we're gonna check at that. It's coming up relatively soon.
When was the class information set to the sponsors? In case people don't know if there are one or two.
It's mostly out now, but I think the mailing of all of this occurs. It's in process today, but it's done, I think, by the middle of February. So some of it is not out yet. If you've logged into Plan Focus, the information is there as well. So it's all readily available. Oh, okay. Okay. Other questions, thoughts? All right. Okay,
I'm
thanks.
going to get you the date before whoever the person asked the question about the mailing date.
Sue, one last check. Do we have any more information? Okay. All right, we'll take a look at that, and since we'll be around for a little bit, we'll report back with that additional information. right, thank you for your time. Thank you.
If you would like to grab lunch, this might be a good time to do it.
For those on the webinar, we're going to break for lunch. They're just going to grab it and then come back to their seats. So it'll only be a few minutes.
I had a question for you, because I know you weren't expecting me, so, I mean, I'm just going to wait.
I'm sorry to interrupt your lunch, but I've got an announcement to make. We have an answer to the question. So the question was around the deadlines for what needs to be done when, and I just want to clarify what's going on. So TI-CREF is taking care of the notification, the fee disclosure notification for all of you who are active, for all of your participants, both active and terminated participants. The information that we don't have is for eligible non-participants and for participants who may not have assets record kept by TI-CREF, so they're with another record keeper under your plan. The deadline for us to receive that data for that segment of your population is March 1st, and the deadline for us getting out, and again, we'll take care of the mailing. The deadline for us getting the information out to your employees is March 24th. So we have 6 weeks, 5-6 weeks to get that done. Okay. We're going to take care of the mailing, right? But you need to take care of a subset of the data. All right. Thank you. Okay. The question is, the question is about eligible non-participants and what exactly that is. All plan documents define eligibility, so it could be that a person can voluntarily contribute to the program, say after a year of service and age 21, but they're not participating in the program. So they're eligible to participate, but they've elected not to contribute to the plan, so that's an eligible non-participant.
There are reports online to help identify who those folks are with the particular status code. So if you need help with that, again, I suggest you're welcome to call me if you need assistance with that.
Mm-hmm.
So, it's really all about, thank you, it's really about taking an overall look at the plan financials and what makes sense for you and your particular relationship. As Robert mentioned, it's sort of, we're still at a sort of status quo as far as what TI-CREF is responsible for. On an individual basis, I'll sit down with you and we can talk a little bit about what makes sense as far as what we can offer to the participants based on how the revenue is generated within the particular plan. So, for example, if you're looking to conduct education meetings, one-on-one sessions, we'll take a look at the numbers together and see where it makes sense where we can leverage additional resources. If it's not within our field consulting group, perhaps in another way, we can try to address your needs from an education standpoint. At the end of the day, the financials sort of drive the model, but we'll work together with that because we obviously have some flexibility there. But we'll work together and we'll figure something out that makes sense for you and your participants.
If you all go into the plan focus part of the website, the password, there's a tab called Education, and it talks about the multi-class structure, and it does give you the breakdown of what the fees look like and all that stuff. So the detail is there. I don't know how we find out what structure, what class structure, whether like R1, R2, or R3. I don't know how to find that on the website.
When you go onto the website, if you go select the Investments tab, all right, so we value the assets as of December 31st, 2014. Okay, so that's how you were determined what share class was determined as far as what you fall into. If you go onto the website today, you can get a rough estimate of where you are in CREF. If you just look at the Investments tab, and then on the left-hand side of the silo, select Show, where you can break down the individual types of information. Click on the Investments piece, and then you can actually select just the CREF funds. And then that will pull up just those CREF investments and show you the overall market value for CREF. So if you're under 20 million, you will be in the R1 share class. For the most part, most of the folks in this room would fall into the R1 share class with maybe a couple of exceptions that are R2. And the other thing would be that once you qualify for R2, once your asset threshold goes above that, we review the information and we'll put you in R2 automatically. There's no action for you to require, and you won't have to go back if market fluctuation draws you backwards. But the information's out on Plan Focus under the Investments tab. You can actually see your market value in prep as it is today, or you can run a report and look at it as of December 31st, because that's the date we use to value those particular assets. Does that make sense, Mia?
Yeah, so actually, if you just go to the picture I just mentioned, it shows you a comparison of where we currently are, and it says, for me, we prep R1 accounts as of that date, so it's on R1.
Yeah. Okay.
Thank you.
Thank you.
We'll be here a while if anyone else has any questions.
We're keeping a tight time schedule here. So the original agenda for today was Suzanne Bogdan of Fisher & Phillips to talk about employee contracts. We asked her back in the summer to use this time period, this time slot to talk about employee contracts, because this is exactly the time when this is on your plate. So we figured this would be a really good subject to have. In the meantime, TIAA Sue Spunzo wanted to come and talk to you about their changes, and then with the Acts 153 and 168 confusion, we wanted to add that to the agenda, and that's why we have these three kind of disparate subjects this morning. So Suzanne Bogdan came up from Fort Lauderdale yesterday, pre-Clipper, I think, and so she's here to talk to you today about employee contracts, the creation and enforcement of employee contracts. Suzanne.
Thank you, Emily.
Okay.
Put this down a little bit, a little shorter. Okay, so any of you that have been in my presentations before, it's open question time. We have a few hypos for you to work through as well. Now, for those I don't know and I haven't met, I'm the chair of our firm's education practice group. I'm the Fisher & Phillips, and you've met Susan Garrett before. She's with our Philadelphia office, or Radnor office, of Fisher & Phillips. And we work with schools across the nation, independent schools primarily, although we have kind of a mishmash of others that jump in there as well. And so we know your industry, and we know some of the issues that you come across, and that's what we're going to be here to try to focus our concerns with. So let me get my glasses on so I can see you. And you might have to remind me to repeat your questions, or I'll get chastised, and we don't want that. Okay. All right, so let's see how we are moving. There we go. Okay, so we're going to start out with a hypo. So the first grade teacher is repeatedly absent, particularly on Mondays. Her absences are creating concerns among the parents who complain about the large number of days that substitutes cover the class. So the question is, can you terminate the teacher for excessive absenteeism? That's our first question. And I guess actually kind of the related question you see there, would it make any difference if the employee in question was the secretary or administrative assistant in a lower school office? So what do you guys think? So the question is, do we have a policy on it? Okay, that's always a good question. Did you warn the teacher? So do we have a record of some performance issues? Yes. Possible FMLA issues? What are we talking about here today? Right, and so that's when you have when you have contracts, and we're going to talk a minute about what all might be a contract, with an employee is going to depend on what your contract says. Okay, we always have to remember, in fact, when you talk with your lawyer before, I'm sure, about separation of somebody, your lawyer should be asking you, do you have any document like a contract or a letter agreement or a commitment letter or whatever you're calling it that is going to potentially impact this decision making. So that's where we are. It depends on whether you can terminate any of them, whether it's the lower school legal assist or administrative assistant, or it's the teacher or anybody else. We first have to know what documents, whether it's handbooks or other kinds of things, but in particular, contracts that might impact that decision making. So let me talk about contracts in schools. And contracts in schools are that you guys, I hope you've heard this before, you are one of the most unique industries in the United States in that you provide contracts to almost all of your employees, or at least large segments of your employees. And schools do different things, but most other what we call corporate America only provide contracts to like their CEOs, or sometimes if they have these, VPs of sales, they might have a contract that outlines their, sales commissions and other kinds of guidelines. But other types of employers in corporate America and other types of employees don't get contracts. I'll be honest, I've never had a contract. In all the years I have been employed, I've never had a contract of employment. So, you are unique in that respect. And I always get this question. So, but we have a contract, but we're still, Pennsylvania is an employment at will state, right? So doesn't that help us here? And so here's the issue. First of all, let me tell you, let's talk about what employment at will means, okay? So employment at will means that either the employee or the employer can make a decision to end the relationship at any time without cause and without notice. Okay, so you don't have to have, you could say, you know what, Suzanne, I really don't like the style of shoes that you're wearing. And I've told you before that you're going to have to upgrade your shoes. And I'm just over it. I'm done. Employment at will, you could terminate me. Okay, there's nothing that precludes that except all of the exceptions to employment at will. And the exceptions are huge. So no, every state has employment at will except Montana, okay, all 50 states. But first exception, if you have a contract. And if you have a contract, then you have to look at what the contract says and to determine whether it changes employment at will. And the two things that typically in a contract change employment at will are going to be if you promise to employ for a particular term, okay, and schools want everybody to be there for the full year for that continuity. And the second thing is if you've limited your ability, remember I said it could be without cause and without notice. If you have a notice provision, okay, that you must give a certain amount of notice before you can terminate or pay, then that's not employment at will. Or if you say, we will only terminate you if there's reasonable cause to terminate, and then you define it all these different ways, that is not employment at will. So now employment at will, if you've got those kinds of agreements, is out the door. And now you have to comply with your contract and whatever it says, okay? The other kinds of things that eliminate employment at will is that you cannot, even if you don't have those contractual provisions, you cannot terminate somebody even under employment at will. Doing so would violate their statutory rights, okay? So, for example, you can't terminate somebody because of their race or their gender or their, in certain areas, sexual orientation, their religion, their national origin, because they had a family medical leave, situation, because they have a workers' comp claim, any of those types of things. And so from a timing perspective, oftentimes we have to look at where that falls in the category of, they weren't performing well, then they had the workers' comp injury, and now we want to terminate because it's employment at will. There's going to be a claim that you've retaliated. Okay? So I always like to make sure that we know from the base what employment at will is as we go into, should we have a contract? What should it say? What are the terms for it? Any questions so far? Okay. All right, so what your practices are that we see with all the various schools. Some schools give contracts only to teachers, because those are the ones primarily we're interested in that continuity for the school year. Some give them to administrators and teachers. Some give everyone, from the janitor to the head of school, contracts. And there are some accrediting entities that we've worked with that actually want you, as a part of the accreditation guidelines, to have your employees or at least your faculty under contract, because again, it's for that continuity purpose. So you always have to know what your requirements are. Now, The other things that we see is that you often don't have your contracts reviewed by your school council. Oh, this school uses a contract. We like that contract, and we're going to take some provisions out of there. Or we bought something off the internet, or we saw on a listserv, or whatever it is. And so the thing you need to know is that you have to make sure that your contract, whatever it says, is both internally and externally consistent. And the externally consistent means that got to make sure it's consistent with whatever other writings you have out there that talk about and define the relationship. So you mentioned employee handbook or policy. And so we got to make sure that our handbook doesn't conflict with what we're saying in the contract. Okay? And we'll talk about why in just a second. So we want to make sure that you are using contracts. Make sure that they're drafted right for your institution. And then periodically you should have them reviewed because laws change, your experiences have changed. You might want to have something in there to protect a particular issue or to address an issue. So, those are kind of our guidelines there. Now, what are the pros and cons of having a contract? And as an employment lawyer, and as Susan will say as well, we would prefer nobody have contracts. We'd like to go and eliminate as many of the layers as possible. But we know that for you, this continuity, this, in the having the full year or at least a commitment to full year is important for you. So that's a good reason, actually, for you to have a contract. Another reason is that it is an industry standard. So when you're out there and you're interviewing people that might be coming from California or somewhere else, they're expecting that they're going to get a contract, and it's going to have some protections in there for them. And so for competitiveness purposes, that may be another good reason. And then in some situations, with some limitations, we can build in remedies. Okay, so for example, a liquidated damages clause, if you chose, so that if an employee breaks their contract, and so you expected they were going to be there until June or May, and they decided in December that, you know what, they're really just going to go do something else, that there may be, we don't like, the law doesn't like us to use the word penalty clause, but that's kind of what it is, that there's a payment penalty that covers the cost, essentially, and the inconvenience for you to replace that person and to go out and do another search. Now, any questions so far? I know I'm going kind of fast, but I want to make sure we get through everything. So the cons are, number one, it does it limits your right to terminate if you've not drafted your contract in a way that gives you good flexibility. Okay, so that's going to be something we're going to discuss. Where can we have that flexibility? It does also limit your right to change terms and conditions if you're not, again, flexible as to duties, responsibilities, time of reporting. So if you put too many cut and dry details in there, then you're, potentially upon a challenge or a question, that's what you're stuck with. Like I remember one circumstance down in Florida, we did have some days that were prior to the school year in which the teachers were coming into work. And you guys all do that, the pre-teaching days or the training days, like usually a week before school starts. And so one of the Florida schools had a teacher that said, I'm looking for my pay. I'm like, looking for your pay for that extra week. My contract, the way the contract was drafted was it started on the day the children come back. And it extended to the last day of school. So the before and the after were not picked up by the language of the contract. Okay, so, and then also you guys have a lot of weather times, and what if you have to extend your year maybe by a few days or by a week? You want to make sure it extends and matches whatever the school determines the calendar to be at whatever time of year based on circumstances that maybe we can't anticipate today. So those are some of the things we just want to make sure you're building in your flexibility. It could require you to make a payment to the employee if you violate its terms. Okay, so if you can only terminate for reasonable cause and you decide, this person is just not connecting with our community and we've got so many parent complaints, we're just going to have to let them go. Doesn't really rise to the level of how you defined cause. And so now you've got a commitment that you're going to pay that person through the end of the school year. So you can terminate, but you got to pay. unless contract gives you flexibility to do something other than that. Now, the other thing is you can't force the employee to stay working any longer than they want. And so that's something to always remember. And I'm sure many of you, I know I've talked to a couple of you this year, and you've had several employees, teachers, that have left mid-year. I mean, we can't force them to stay, so that may be something where, again, that liquidated damages clause. And then the other piece is you draft the contracts, okay? So any ambiguity in the contract is going to be construed against you. So that means that the interpretation that would be most favorable to me, your employee, I get. Okay? Another reason to have it reviewed. So it's giving you a second for any hands. Okay, we have a few more hypos in a minute, so I get you talking again. So contracts are legal documents. I just mentioned ambiguities will be construed against the drafter. Now that means both internally and externally, but primarily internally. So if you say something at the beginning of the contract that is inconsistent with what you've said somewhere else in the body of the contract, whichever version benefits the employee, if there's a challenge on that provision, will be the one that will be enforced. Okay? Other little things, just so you know, when the contracts are challenged, that parties are presumed to have read all parts of the contract. Sometimes that can be helpful to you, and sometimes when an employee has made a little change and you didn't notice that they crossed something off and initialed it, and you just got it back and you put it in the file, that is going to be something where you assume to have read and assented to that. Okay, so keep that in mind. And then we're going to try to read all pieces of the contract together to give everybody the benefit of the bargain. All right, so now you've got basic principles. So what makes a document a contract? Okay. It is an agreement to employ a particular individual, okay, for a definite duration, okay, with specific duties, a promise to pay compensation or to provide benefits in exchange for their duties, and signed by the person to be bound. So it doesn't have to be signed by both parties, but if there are things in there you want to enforce against the employee, then it should be signed by the employee. Now, let me ask you this. Who should sign that contract first? The employer. Do I have the other version? Since we've only got two choices. The employee. And let me just tell you from a legal standpoint, whether it's a severance agreement, an employment contract, any of those things, I would prefer that you do not sign them until after the employee signs them. Because once you sign it, it is binding on you unless you have a very clear clause that says this is not a contract, does not become a contract unless you execute it within X number of days and return it to the school. But the more important thing is if you're going to sign it afterwards, it does give you that opportunity, and you should do this, have somebody review what you get back to make sure there aren't any changes. And we have had plenty of circumstances where there were little changes. Like when some employers have, you know, a termination without cause. Maybe we'll give you 30 days notice or 30 days pay. Employee just crossed that off and made a little initial, and that's not acceptable to the employer. So you can say, no, that's not our term. We're going to give a new contract to you that now, if you want to work here, you need to execute. Okay? Okay. All right. So regardless of what you call it or don't call it, the document that you're giving to your employees may be contracts, okay? We see lots of different names, and sometimes things aren't named. It's just, you know, dated in Dear Suzanne, you know, and we're happy to have you return to us next year, and, you know, we intend to employ you in this position, and you lay out the things that I told you make a document a contract. And so just know that whether you're calling it a letter of commitment, a letter of agreement, a confirmation of employment, that it's not what you call it, but it's what's in the body that matters. Okay, so you want to go back and take a look. Maybe you thought we don't have a contract, because I do get that point to me all the time. And usually, you know, whenever somebody calls us to terminate, that's one of the first things we say. Do you have a contract? No, we don't. What do you have with the employee? Any document that is signed that outlines terms of employment. Oh, well, we have a letter agreement. Okay, send me your document, your letter agreement, and let's take a look at it. Okay. So what needs to be included, or what do we recommend? So clear terms of compensation. Okay, that's what the employee is interested in, and certainly you want to make sure we're all on the same page. Most schools do pay over 12 months, so you're going to make that very clear. And so even if it's a 10-month employee. So if it's a 10-month employee and they're paid over 12 months, okay, if they quit, so let's just say, is that employee compensated for 10 months or compensated for 12 months? I hear 10 months. Okay, so as the responses are, it is work for 10 months, it's pay over 12 months. And so this, of course, puts you as another unique entity in the world, and that is that now when you have somebody that leaves early, you got to recalculate their pay and catch them up at the end for the deferred pay. Or if you have somebody that takes an unpaid leave of absence in the middle of the year, you got to recalculate what we're spreading and how much is deferred, and it creates machinations. Let me tell you, difficult issues to deal with. So your contract, you want to also make sure it's very clear what can be deducted from that pay, so that there's no question. So if they take an unpaid leave, you say we're going to pay you X amount of compensation, subject to normal deductions and deductions for times that are unpaid leave, loans, these kinds of things. So. Yes, I have a question.
If you don't have that kind of incentive, you have somebody who's taking incentive of that. Does that make the contract null and void?
Okay, so here's the question. If you don't have the reduction for unpaid leave, okay, in your contract right now, and somebody is actually taking leave, does that make your contract void? Here's the other way you could save yourself in situations like that. There's a couple of, your question raises a couple of issues. One, if your employee didn't challenge it, because everybody knows it's unpaid leave, no harm, no foul, okay? If your employee does challenge it, maybe you have incorporated the terms of your employee handbook into your contract. And if so, then your employee handbook would say this is unpaid leave. The other thing is the clear documents that you would have given the employee regarding their unpaid leave should be talking about unpaid leave. You're far better, as you kind of look back at your document, to add that language so that it's really clear and no questions come up. And of course, the reason all of these things are in this webinar and seminar is because we've confronted these issues, and so there have been challenges on those issues. Okay. Oh, and suspension for force majeure. Okay, is one. Okay, hang on one quick second. We have a question, and then we'll get to force majeure. Yes. What we normally would suggest is that if this sounds like it's going in a letter form, but I'm not sure, okay, and many of them do, you should either have something in there, honestly, the best thing is to have the letter go out, have the employee sign it, and let the employee know after they've signed it and returned it that the headmaster will sign it and return a signed copy to the employee. That's the best process. Now, some people are just not going to feel comfortable with the headmaster sending off something that looks like a letter that's not signed, okay? So then we can add some language. Then we can have the headmaster sign and add some language that would say, this document is not an enforceable contract until the employee has signed and returned it and the headmaster has countersigned below, and we'll have a separate line. So we could do something like that, okay? Okay. Suspension for force majeure events. What force majeure is, does anybody know what force majeure is? It's a cool kind of a term. That's exactly right. That's right. Acts of God, school burns down, snow collapses your roof, hurricanes, that kind of thing. And so after Katrina, everybody realized when there were lots of schools in New Orleans that just were not going to be able to open again, that they needed to build something into their contract to make sure that the school was not responsible financially if they can't reopen. So that's what that is. Yes, I saw a question back up. Okay, so the question is on the reduction for loan piece when we talked about compensation, should you require teachers that have a tuition obligation, so maybe they get a partial tuition remission and then they have to pay the rest, should it be payroll deduct? And that is what most schools do. There's no problem with having that as a payroll deduct. It's a debt that they owe you, and then it would still be evidenced by an enrollment agreement. Okay. Yeah, I would recommend that. That makes it easier for you. Right. One more question. Yes. No. The question is, do we not recommend that you pay 10 months over 10 months? Okay. There was a period of time, actually, where because of the deferred compensation IRS rules that you needed to make it required in your contract, you don't have to now. And so you can, and many schools do, they'll give employees option. You want to be paid over 10 months or paid over 12 months. And that is perfectly fine. Some schools don't want to give the option, and if you don't want to get the option, then you go ahead and let them know that you will be paying them over 12 months. Okay. Good. All right, so your math teacher is also the JV coach. And you pay $2,500 stipend for the coaching duties and spread that pay over the full 12 months of the contract. The JV tennis season starts in April, and he doesn't show up for the first practice, late for the second practice, parents are upset by this point, and then he doesn't show up for the third practice. So you decide to terminate the coaching part of his duties. So what problems? So she's saying we have to pull back what we've paid, and that's right. Okay, we've already paid this guy about $2,000, a little more, out of the $2,500 that we're going to pay him for coaching. And so it's now we're going to, it creates these employee issues when you do that. We're going to have to re-deduct this advance, essentially, that we've provided this employee. It just makes it a little bit more difficult. So yes. So the comment is, since he's still working in another category and he's still getting compensated and will through June, or actually whenever, June 30th, I guess. So can you just say, we're going to take it on the rest of the pay that we owe you? Absolutely, we can. In advance, we can do that. And remember, teachers are exempt, so we can also do that without worrying about minimum wage and overtime and those kinds of categories. What some schools do, and so this is something for you to consider. I'm not saying that this is one where there's not really a best practice, but it's just something to think about when you're putting your contracts together. Is should we pay the coaches over the 12 months, or should we pay the coaches at the end of their coaching responsibilities, or maybe halfway between and the balance at the end, with that carrot being you got to finish all those duties before you get the final ticket, at the end of it. So that's just something to keep in mind. And then if you're going to do that, then that needs to be built in, either by addendum. A lot of schools use a separate contract for coaching. Rather than building it into their regular teacher contract, they'll do a coaching contract that has duties and responsibilities. They're a little bit different because CPR, requirements and complying with athletic responsibilities, all those kinds of things are going to be different than a teacher contract. Did you have a question? Yes.
This is how my school practices. I've had to run and then pull back. And most of the time people understand, but there has been a cut to that off and someone's on FMLA, then is that coaching piece a part of their primary job responsibility? And I said, no, it's not. We have a unique way we calculate coaching things. So I've always said that if it's above, we hire coaches for all of our practices. So if it's above the 3 points and you're not fulfilling it, you just take it away. If it's a part of your salary and it's at 30 points, you can't grab it back. That's what I directed on. I don't know if that's actually correct.
Okay, well, there was a little bit of a complicated explanation. I'm not sure I can repeat for the benefit of our other audience, our web audience, but it was a method of basically trying to determine whether or not there's somebody that's on FMLA, and so they can't fulfill their coaching responsibilities. Can we reduce their pay for the fact of the coaching responsibilities and say this is a whole separate job that you're not fulfilling that we would normally be paying you for? and they have a system that they assess. And without knowing more about your system, I think we could discuss it separately, but it might be, I can't really tell as we're sitting here right now whether that would be an FMLA issue. Okay? Okay. All right. So you're really interested in pursuing a particular candidate for a USAP course. This teacher has 4 kids, needs tuition remission for all 4, and maybe your school gives 100%, okay, tuition remission. Policy provides for only 1 student at full tuition remission, and the remainder must apply for financial aid. Your head advises you to add to the contract that all 4 kids will receive full tuition remission. So the question is that okay? Some say no. Does anybody say it is okay? Okay, so we've got the opposing view that we can, they're individualized negotiations, we can have a special deal. So let's talk about that, because let me just tell you, are there any heads in here? Okay, let me just say, heads of school love to give perks like candy, okay, when the moment is right. So we have to help you be careful. So let me just tell you, you do need to be careful in giving perks that fall under either the tax provisions or ERISA or the healthcare law, okay? And the reason is that you're going to potentially violate one of those laws. And so, and of course, you have the other whole component of this is our policy, and from a discrimination standpoint, we need to be consistent. Okay, so I like you, and I'm going to give you a little extra perk. I like you, I'm going to give you a perk. I'm not liking you so much. I'm not going to give you that perk. Okay, that then becomes, something that is an unfairness, and it's a, it becomes a concern and a potential discrimination issue. So what you do need to know is that the tuition remission, that is a tax code problem. You have got to follow your policy in handing out that benefit. And so your policy can provide different benefits for different groups of employees as long as there's a reasonable classification. But if you're going outside that reasonable classification, depending on the level of the employee, there could be a tax hit on them, okay, where a certain portion of it has to be called taxable income. And in some cases, if it's a highly compensated employee, the entire tuition remission, every dollar, even that you would have given for free, becomes a taxable benefit. So it can be very serious. And then health and things like that. We get that quite often where we want to pay for this person that we're bringing from California. They had full family coverage over there, and we want to provide that for the full family here. Our policy is different. Again, it becomes an ERISA or a health care problem for you to give an additional benefit that you don't give consistent with your policy for all of the employees, and especially if they're highly compensated. Okay. All right, so you drafted the teacher employment contract. It's for a full year. The only method of terminating is for reasonable cause. Reasonable cause is defined as moral turpitude, whatever that means, violation of the student-adult boundaries guidelines, sexual harassment, drug or alcohol abuse, or gross misconduct in connection with teaching duties. Science teacher's new to the school and was a late hire, how that works. Within the first 2 months, it's clear the science teacher is not working out and parents are now complaining. So can you terminate, and what's the impact of termination? There you go. You're exactly right. So you are, like I said in the very beginning, yep, you can terminate regardless of what your contract says. And so looking to your contracts is going to tell you what your monetary liability is going to be. Okay? So it's important that you make sure that the terms, for example, your reasonable cause and all of the other termination provisions in your contract work for you, and you're thinking up ahead of time, or your lawyer is thinking with you on what are the kinds of provisions you should consider having. Now, one of the things that a lot of our schools have, not all of them, but I'm going to say now we're probably at about 75%, have a 90-day introduction clause or probationary period, whatever you want to call it. During that period of time, we are defining the employee as an at-will employee. okay, so that they don't fall under the cause provisions, they don't fall under any pay provisions other than pay for the days that you work. Now, the one thing you have to remember is that if we're going to incorporate a liquidated damages provision, which is one of those provisions that says that if you break the contract, you got to pay us $2,500 or something like that. We can't use it during the 90-day introductory period because remember, at will means either party can leave at any time. So in that first 90 days, the employee is free to leave and you're free to separate them. The good thing about a 90-day introductory period, and I would only use this obviously for new employees, so that's the way our clause reads, and it also reads it begins on your first actual day of work. So if your contract says this is from July 1 to June 30th, this introductory clause begins on the first actual teacher day of work. So it's going to be during your training week, okay? And it's 90 calendar days then, we make that clear. But the other thing is, so if you do separate somebody, okay, administrative agencies, judges, juries, anybody that might be looking at this later, if a claim was brought, they understand that you make a mistake in hire sometimes, and they expect you to address it quickly if you're going to do that. So they fully embrace this 90-day introductory concept. The other thing is they don't expect as much documentation that they're going to look at to assess whether it was an appropriate separation. So there's some benefits. Not everybody likes to use them, but some do. Yes? No, we don't usually say that because you know why? The question is, I'm sorry, after the 90 days is up, should we put something in the file to evidence that they've passed their 90 days or that they're, you know, now they've completed that? You could, and maybe you'll do a little evaluation before then. Okay, yeah, and if you're going to make sure, if you're going to use your 90-day introductory clause, that you do that evaluation, not on day 88 and certainly not on day 90. Do it more like day 85 so that you have that time to make the decision, and especially if I'm absent, you know, to make that decision before 90 days to separate them. Okay, so keep that in mind. And then I think that was actually it. So what are the other clauses then? You also want to make sure that if you're using a reasonable cause provision, and I will tell you what our schools typically do. They have the introductory period, then they have reasonable cause, and then they have some other provisions so that they all kind of work together. So if you're going to have reasonable cause, make sure it incorporates those reasons that you're likely to find that are serious reasons to terminate, in which you're going to cut the pay and benefits off, or the pay off essentially, at that time, and then benefits will cease pursuant to their benefit terms, so end of the month typically for insurance and that type of thing. But use language that everybody can understand, okay, so moral turpitude, I mean, I still don't exactly know what that means. It's a very highly litigated term because it means something different for every community. It's what's appropriate in your community as to whether it falls below those mores, okay? So anyway, you can tell I don't love that language. Okay. And then have some other discretionary language in there as well. And then other provisions, termination without cause. And I'll be honest with you, this is the one that most schools use, okay, because it is rare that they're going to terminate somebody for cause. And even if they have the basis to terminate for cause, the one thing you have to remember, if you're saying we're terminating you for cause under the terms of our employment contract, if you're challenged, it is your burden to prove that cause existed, okay? And so if you don't want to take on that burden, and so it gives somebody a little bit more of an incentive to challenge you, then you just have this clause that says we can choose at any time to terminate you with notice and 30 days pay, or notice and 45 days pay, or whatever that would be. That's the limit of your liability at that point, 30 to 45 days, whatever you put in that clause. Okay? And then we want to have, you know, disability, death, and then reduction in force provisions. And so that, you know, and some schools like to have the reduction in force provision say either if we have to, you know, maybe we are not have the finances that we thought we were going to have, or, you know, less enrollment in a particular area, we make the decision to either separate you or to reduce pay and benefits. so that it gives you that flexibility. Maybe you don't want to, let people go. You feel a long-term commitment to them. You want to retain them. But maybe if everybody took a 10% pay cut, you could make it this year and still keep everybody fully employed. So we want to, again, give you that flexibility. And force majeure, we talked about that already. We'll have that in there. A resignation, and so, what if an employee is going to resign? Are you going to require a certain type of notice, and are you going to have penalty or that liquidated damages clause if they don't give you the notice? So you have to make sure that clause, if you're going to use it, is enforceable. It's got to be worded in a particular way to make sure that, in fact, it's enforceable. Okay. Oh, yes. The question is, what should be in the contract versus the handbook? And can we move some things, for example, a 90-day introductory period from the contract to the handbook? The only thing I would say about that, we're talking about a termination provision, okay, and we've got this person under contract. If you're going to, I would still reference the probationary period or introductory period in the contract, but if you don't want to go into all the details of it, then you can say, the provisions of which are set forth in the employee handbook. Okay, and there are other kinds of things, duties and responsibilities, which we're getting ready to talk about. You can incorporate the terms of the employee handbook for some of those things, but you just have to make sure. See, this is where we said you got to make sure the documents are talking the same language, so that the contract is internally and externally consistent. So we're going to incorporate the terms of the employee handbook into our contract, so that if there are things that we're going to be supplementing by the employee handbook, we've got it there. Now, if we do that, our employee handbook has to define employee as far as, are you an at-will employee? Are you under contract? In the same way that our contract does. And that's not hard to do, as long as somebody is focused and looking at that. So when a school sends us their contracts for review, Susan and I are going to look at the entire thing. We're going to say, give us your employee handbook. We're not going to review your employee handbook to tell you what to change. We just want to kind of look at a few pieces in there that are important for this process to make sure that when we finish with the contract, it is consistent with your handbook. And if there are things that you need to change in your handbook for that consistency purpose, we'll tell you what those are. We'll give you the language. Okay? All right. So, you can have, some schools have a big duties and responsibility clause. Some have smaller clauses. Some will have creation of specific lesson plans, maybe a special program. Some will want to have a number of hours and duties as far as the days and things like that. And a lot of that, the more specificity, I think, is driven by the difficulties they've had in that particular school. So this is, again, something where you can set those expectations. You can say, days and hours of work as communicated to you by your division head or by your department head or whatever that's going to be. So you don't have to have it specified, as long as it's clear when they're working from, July 1 to June 30th, or beginning of the school year through the end of the school year. Other things that I think are important for here or the handbook are going to be things like you want to make sure that they understand you're expected to carry out all those duties and responsibilities normally expected of a teaching staff. So that's going to be, in some things like participation in extracurricular activities, open house events. If everybody's expected to be there, let's put those kinds of things in there. Supervision of the lunchroom, drop-off, pickup, any of those extra things that are not technically teaching. We want to expand to say this is all a part of what our expectation is. Okay, so some schools will want to have an acknowledgement in the contract that any intellectual property you create on our dime, essentially, is our property. Okay? And the same with inventions. We have had some schools where the teachers working with the students have come up with some pretty amazing things. And so, we can put some clauses in there that make that very clear. And you may want to have something like that as well if you've got students involved in the enrollment contract, so the parents understand these inventions are, of the school as well, unless you're going to say that they're student owned, okay, as a group, that kind of thing. So you have to be thinking about those issues when students are involved in creating inventions. But yes, so we can put that clause in there. So things like lesson plans, special curriculum, all of those types of things that are important. Some have had, music teachers that are creating music and composing, different kinds of things, and then they want to, take all of that with them when they leave. So if you don't have a clause that's very clear in there, that could be a problem that you end up fighting down the road. Confidentiality of information gained through employment. So they have access to parent, teacher, parent and student information, home addresses, emails, phone numbers, contact information. They have, sometimes they might have knowledge of financial issues, medical issues, disabilities, of course grading discipline, why the student was let go, all of these kinds of things. Possibly they're involved in strategic planning, things that might be involved with accreditation. So all of those types of things that should be staying with your institution and not be walking out the door. You want to make sure that they understand they have a duty of confidentiality. And it's confidential as long as, you just need to know from a legal standpoint, you do have to take steps to maintain confidentiality of information. And if you kind of publicly put something out there, you want to show your accreditation report, it's not confidential anymore, okay? Compliance with employee handbook we've talked about. So if you're going to have at-will employment, we're going to add at-will employment instead of all those other termination clauses, okay? I like to have in the contract the consent to do a full background check and to update it as the employer deems appropriate, okay, without additional consent, so that you don't have to run out there every time and get their consent to do those updating. And of course, you're going to be hearing about your time frames, and I know you probably know some of that already. This one paragraph also contains that clause for a reference check and full background investigation. My viewpoint is we might have other documents that contain these provisions, but darn it, whenever I've needed to put my finger on those, I can't find the one that Suzanne signed. So I like to say if you're going to have a contract, let's put those important things in there so we know they're at least in one spot. We're going to have promise of truthfulness in all of the statements that they've made in connection with their hiring and qualifications. I mean, how many of us have read the newspaper about, special coach over here that never did actually have the degree or never worked at, Princeton or, wherever it was that was important to you. Amendments to the contract need to be in writing. So who needs to sign it? Employee and the school need to sign it. The contract should not be modified unless both parties, and it shouldn't just, when we say school, I like to say the office of the school, head of school, or if it's going to be the director of finance, not just the school, because we don't want the athletic director suddenly making a little change over here for somebody. We want it to be very clear who has the authority to execute a contract. We want to make sure you can assign it. Here's a good example, Springside Chestnut Hill. At one point was two separate schools, and so you never know if you're going to merge, if you're going to go away, if you're going to change your name, if you're going to change the way that you're established, and you want to make sure that your rights and obligations can be assigned. But you don't want the employee to be able to do that. You don't want suddenly Suzanne Bogdan showing up in Leonie's place to say, I'm going to be your third grade teacher today. So the employee can't assign this very personal services contract, okay? And then this is discretionary on your part to put in an attorney's fees clause, that if you have to move to enforce or if there's any claims that come out of the contract, that the prevailing party gets their attorney's fees or the school gets its attorney's fees, okay? All right, so we're moving into dispute resolution. So now you don't love each other quite as much as you did in the beginning. You have to think about that at the beginning, okay? So do any of you have a mediation option in your contract? Nope? Okay. Some schools do, but maybe only limited to the head of school. Some will have it at any. So, but that basically just says the parties will try to get together and resolve their differences first. It's now, arbitration is another clause that a lot of schools will have. Arbitration means you're not going to court, going before a private entity, a person, typically a lawyer, maybe a retired judge, to determine who's going to win in your dispute. Now, here's my down and dirty on arbitration, is that working in an employment law firm for a long time, some parts of the country it's very good. You can't get away without it in California, to be honest with you. But a lot of other areas, it's not so good. It's not necessarily faster. I've had arbitrations that took 3 years to complete. Okay? It's not necessarily cheaper. This one arbitration that took 3 years is also very expensive. And it is, however, typically private. It's not something that's going to be in the public records. And so that is not going to be something, therefore, that for the most part, and I'm going to put that asterisk there, that the reporters are going to see. Okay? It must be carefully drafted to comply with state and federal requirements, or it won't be enforceable. The time when the reporters might pick it up is if somebody files their claim in state or federal court, and then you move it to arbitration. So there's the complaint. It's still going to be in state or federal court. So it's not completely private. Okay, agreement to waive jury trial is what a lot of our clients use. And this is the opportunity for both parties to say, we'll go to court, but we won't use a jury. Okay, because juries, quite honestly, are more sympathetic to the plaintiff, to the employee, who's usually the plaintiff. So you can still have a judge who knows the law, is not afraid to make a hard decision, determine the dispute, but instead of using the jury, you just go directly to the judge. Now, Pennsylvania courts do enforce this if it is a clear, statement and it's reasonable in your contract. So you just want to make sure the language is proper. And this is going to be in the public records, okay? So, because it is a regular court proceeding. Okay. And then a last couple of things, choice of law. It is important that you say Pennsylvania law will apply and where you're going to address the dispute. We should address it here, okay, in your county, so that you don't want to be, somewhere else, or maybe where the employee has moved to, okay, or something like that. You want it here under your law so that you've got your lawyers, your witnesses, and that kind of thing. And then the final couple of points is managing your contracting process. These are important documents. They're legal documents, so you want to make sure that you're not making changes to the document without working with your lawyer to make sure the change makes sense. For those reasons we talked about earlier, laws change, interpretations change. And then somebody needs to be reviewing the contracts as they come in from the employee to make sure no changes were made and cross-offs were done. You should limit the people in the administration that have access to them. So if you need to find that original contract, we've got a file of contracts, or they're in their employee file, whichever way you do it, limit whoever has access to that file, and so that it's available when you need it. And let's see. I am done. Any last questions on your contracting process before I turn you over for Pennsylvania law issues? Yes.
I have a question for this group as a whole. Do all of you have all of those? I would basically just say, this is what the responsibility is, this is how much you're getting paid, that will state, and the rest of it is up in there. I feel like that would be very intimidating to my community. I can tell you if I did this right now and I do them this, I wouldn't have any interest left. I mean, it's really intimidating. And it's not a one-page nice letter or anything. This is a multi-page document.
Right. So Mina has asked, who in here uses contracts, or do you basically have employment at will? See, that's what I see. And I think you see more contracts in different areas of the country. You also see there are some schools that do use employment at will, but it has taken them a period of time to get to that, and it has been sometimes difficult for the community to accept it, and so not at the end of the day, which you convince your community doesn't mean we're going to terminate everybody, but they feel that way, that they feel like they have less protection. They want that big, thick document that outlines, and you don't have to put all these provisions in, but these are the things for you to think about. And obviously they have, PAYSBOA has this presentation for you to have access to look through there, and you can ask us any questions that you want that might come up, that are confusing to you later. I saw another question over here. Well, I don't know, and the question is, we talked about, say you have inclement weather and or we had Hurricane Sandy, for some areas, maybe not quite here, but certainly other parts of our country, I mean, schools were closed for, 2 weeks maybe. So you might have had to extend the school year. And so the question is, well, can we just put that, we expect you to work 188 days, 80 years, really, versus that, work through June 30th, or as may be extended for unanticipated reasons. And so the point here is that, there are other reasons why you might put 188 days in for the compensation piece. And I know a lot of schools do that to figure out how we compensate and what their daily rate is and stuff. My preference would be, and I think a better practice would be to say, here's the term that we expect you to work, although the end term may adjust as may be necessary for extraordinary circumstances, such as, and then give an example or two. Okay. All right, I am going to, I have a couple more quick questions, and then we'll turn it over. The question is, so if there's excessive absenteeism, our very first typo, can we terminate the teacher for this excessive absenteeism? So the point is, in our handbook, we have, you can take so many days off for sick or personal or whatever, and we don't say if you exceed this, or you get to a certain excessive number, we can terminate. And that is a perfect example of why you need to make sure that, you talk through some of those things. You make sure your handbook works with your contract. And so you might have excessive absenteeism, for example, in your contract, but then you look to your policy to see, how do we define that? Oops, we don't. So we want to make sure that we have something, some language in your policy that will make clear what we mean by that, okay, or in your handbook, or in, I'm sorry, or in your contract. Okay? One more question, yes. Here's what I would say. So the question is, can we, and we've had this question come up quite a few times, can we just not give anything? Okay? I mean, is it okay? So what you're talking about is being like a corporate employer, okay, the rest of America. I don't get anything every year saying, Suzanne, we're going to keep you, okay? I just know I'm there until they terminate me or I quit. And so, but the point that you want to make sure, okay, is that your employee handbook, okay, since you're not going to give them a document, that your employee handbook makes clear, the kinds of expectations and policies and the ramifications for not complying with that, so that they are then, and make sure your employee handbook says at-will employment, okay? Or if it's not going to be at-will employment, then it needs to have those kinds of definitions like we talked about in here. Maybe we'll give you 30 days notice or 30 days pay if we terminate you. So it's perfectly okay, and a lot of schools have moved away from giving contracts or letters of agreement or renewal letters or whatever we call it to some of theirs. Very few don't do it at all, okay? What they do is they maybe have a segment of people, only faculty they do it for, and everybody else they've gotten away from it and said, we're not going to give you a paper, okay? Here's the deal. You're employed, and you're going to be employed until we let you go or you quit. Okay? And we hope you give us notice. And so that's employment at will for that group of people. Okay, Susan, are you going to educate us now on Pennsylvania? And we're going to be here afterwards. Well, so if you think of other questions, whether it's on Susan's or mine, we're going to be here to help you out.
Great. So I think you end around 1. So I'm going to try to go through this quickly. But Suzanne and I are going to be here afterwards for any questions. So feel free to ask questions afterwards if we don't get to something during this. Oh, 1:30. Okay, then we'll have plenty of time. Okay. Okay. So as you all know, we had Penn State. It was a terrible circumstance for our state. And many of our legislators have reacted by implementing laws to try to deal with some of the issues that came up there. So what we've seen since Penn State is a couple of changes. There are now different child abuse training and reporting requirements. We also have new clearances that we must obtain, both from our employees and now for volunteers. And we have to do an enhanced review of applicants. So when we have a job applicant come in, we have more enhanced requirements for those people. Let's start with Act 126. So that deals with the training we need to do now. And what it says is that employees who have direct contact with children are required to have 3 hours of training every 5 years. Now, you're going to see this a lot, the direct contact with children. That's a standard that's used in a couple of these acts. What it means in Act 126 is the possibility of care, supervision, guidance, or control of children, or routine interaction with children. Now, who is covered by this? Let's start with that so we know who we have to work with. The prior slide said employees, but it's also independent contractors. So your independent contractors that you're working with need to make sure that their employees have this training. You don't need to do the training, but you need to make sure that whoever you retain, if you're working with a company that has independent contractors coming onto your school, that they have this training. It also includes contracted substitute teachers and non-certificated employees such as custodians, the bus driver, people you don't always think of, but they also need to be considered here. And again, that's if they have direct contact with children. So you can think about who your employees are and whether they actually have that direct contact with children. So your custodian may or may not have direct contact with children. He may or she may work with children because he's in the hall with them, he's routinely interacting with them, or they may never do that. So if you have a painter come in who's not really dealing with children, then they probably don't need this training. And the last thing to just mention is that although student teachers rather, and volunteers are not mentioned, it is recommended for them. So if you do the training, you might want to have those folks come in and sit through it because that's what the department is recommending. What about student workers? They're your student workers. Oh, sorry. The question is, what about paid student workers? Well, are you paying, is the school paying them? Then I think they would definitely be covered by this. If they're having, again, I'm sorry? Yes, yes, I would still cover them because they're going to be technically an employee if you're paying them. And you're saying, what would their position be? Are they a teacher's aide or? Okay. Then I think they would be covered by the routine interaction part of the definition, and I would definitely provide them with the training. Yes, I would do that. Yeah, because you can have a 16-year-old who abuses children, or so I think they would definitely be covered. Oh. Okay. Yes. What about services that are provided by right. So the question is, we understand with regard to independent contractors, the school hires, but what about other independent contractors that come onto the school who may not be directly contracted with you? Okay. And so what we're recommending there is that it's their responsibility to do the training for their employees. But if you have a contract or an engagement letter with that vendor, we would recommend that you put something in there just clarifying that it's their responsibility to provide the training and that they're doing so. Yeah, I mean, it's not your responsibility to train people that you're not hiring, that are not, your employees. But you do need to make sure that if you're retaining someone, if you're hiring a vendor, I would definitely recommend putting that in there, just to clarify that it's not something you're doing. Okay, so, yes. Mm. So the question is, what about someone like a custodial service that comes into your school after 3 o'clock? We'd like to have them have some type of clearance. Well, let me just be clear too. This doesn't limit what you can do. So you can certainly say to the company you're using, we want to see evidence of this, or we want to make sure that you're doing this for all of your employees. What this is telling you is what your basic obligations are. So, yeah, and this is training. So were you asking me about certifications? Because we're going to get to that later under Act 153. But this is just training the employees. There is a cutoff date whereby everybody needs, is there a cutoff date to provide the training? That's the question. Yes, there is a cutoff date where everybody has to provide the training. It's in 2018, so you have some time. One thing that has been clarified by the department, though, is that once you start that training, you've started your obligation. So then you need to do it every 5 years from whenever you start the process. The training that's required is identified on this slide, so there are a number of things. Okay, Colleen? Okay. Did someone else have a question before I keep going? Yes. Now, this is the training. So, no, the training doesn't need to be done until this period has expired. Now, they're recommending that you do it. So even though it's not required, the recommendation is that at least the reporting and the mandatory requirements are trained on. So you don't have to do it, but they're recommending that that portion of it you do right away. Yes.
Will local training be training like you bring someone in to do Title IX training? Because the kind of thing about the colors the same. So if you bring in someone to do Title IX training for the entire campus, would that be considered the training under the 126?
The question is, if you bring someone in to do the Title IX training, would that cover this? The department has really been specific that they want this exact training done. And they do have a provider that's, I think, approved for 2 segments of the required training. You can do training on your own, but you would really need to work with them and make sure you fulfill exactly what they require because they're very specific about it. Yeah. Yes, Colleen? I think that would be very useful to put in there that they are providing the training required and they're providing the background checks for their folks. So yes, I think as a good practice that would be something I would include. Yeah.
I just wanted to show everybody you should probably check into your insurance carrier. You can probably get insurance for free so you know the business to help us comply. The United Educators, most state schools will provide it for free. They're not really free webinars, but it checks the box and gets it done.
And I just
any K-3 schools that get their insurance to
one thing I just wanted to mention on this slide is that one of the things that people need to be trained on is the school's policies related to reporting of suspected abuse and sexual misconduct. So that's something you're going to need to think about with regard to your specific school. First, they recommend you put some type of policy in place. And recall at one of the last meetings we talked about how those reporting requirements have changed now. You can't just tell your employees to report to the head of the school. They have direct reporting requirements. So you want to make sure you have some type of policy in place and that this training cover those policies. And the department has also made it clear that if you need to take more hours to get all this training in, that's what they expect us to do. So some details with regard to, again, Act 126 is that there are no specific record-keeping requirements, but some type of accounting is recommended. The deadline for employers and schools to complete this training is December 31st of 2018. But again, as I mentioned earlier, the department recommends that all current school employees and contractors obtain at least the child abuse recognition training portion as soon as possible. So that's where they seem to be really putting their emphasis. Okay, now we're going to switch to Act 153, and I know this one's really a bear. Go ahead, yes.
And I wanted to do it today because I'm running through the procedure that they're objecting. Do they have any proof that they do sometimes do it? Are they fingers?
The question is if she has an employee who's already been through the training, say 2 years ago, from another institution, is there any record of that, or should they go through the training with the current school? I don't think that they're organized enough to be giving out records of training. I haven't seen anything that is really reporting that very well, and so I would say that the best practice would be to have them go through it again. I'm sure that if you had an issue and you explained to the department what you'd done, if they had it before, I think they're trying to have a good faith compliance with this. But if you're doing the training anyway, I would have them participate in it. Sure. So the question is there a best practice recommendation with regard to Act 126? And there are a couple things. There's no one-size-fits-all approach to this. What we recommend is that you at least try to start training your employees on the one aspect that the department's really focusing on. There are vendors that you can retain to come into your school. We also provide some of this training and can do so. So we recommend that you at least start that process. You do have some time to fulfill it, so you don't have to rush in and do it all at once. But I think it would be good to at least start that process and start at least the minimum training they recommend. Yes. Sure. Right, so the question is, how do we actually go about physically complying with this? What should we do next? And I think you're exactly right. That first you need to figure out who is covered by this. And I would go through everybody on your campus and figure out who would be covered and who wouldn't be. And then there's some flexibility that, in terms of the training. So I would look at the Department of Education's website. They kind of talk about the training, and you could get a sense of what you think would work best for your school. And then figure out, how to implement that. Do you want to have everybody come in for one big training? Do you want to break it up into different groups? And I would try to focus it in on the things that are the most important first and keep track of what you do. Mm-hmm.
And then schedule some time during the meeting, which is a perfect time for them.
Yeah, the question is, could we wait and do this when we bring in our new, after this year ends and we bring a new year starts? Yes, I think that would be fine to do. I think you could bring in whoever's on your campus as of next year and go through the training all at once, and I think that would be a good approach. Yeah. Yes.
into the state rate, because anytime they want it online, their own ledger, and then it's actually, it's not that hard. It's one order you can have it, it's boring to say, but it's very easy.
Well, I was going to mention that. I don't know, I haven't checked in the last few days, but my understanding was that only one vendor had been officially approved, and that was for 2 segments. So I think this is a little bit of a work in progress, and it's going to be developing, but you might want to keep track of that, especially because as time progresses, you might want to do next year's training, do something different, to hit another subject. Yeah, it's on their website. I don't remember the course name offhand. I might have it in my materials if you want to check in with me afterwards, but it's definitely on the Department of Education's website. Okay, so we were going to switch over now. So that's the training that's required. So that's separate. That's training. Now we're going to talk about Act 153, which is the clearances. And this is new legislation. It's also a little bit in flux, you know, from talking to the Department of Education. This is something that they're trying to figure out as well. There are some issues, you know, about who's covered, who's not covered. But generally, employees and independent contractors are covered. Those who have direct contact with children must have these clearances. Also covered are volunteers, but we're going to talk about those a little bit later. So these are the clearances that they must have, the 3 you're used to working with. So those are the clearances that the employees and independent contractors must have. They must have these clearances if they have direct contact with children. And again, that's the standard we've seen before, which is defined as the care, supervision, guidance, or control of children or routine interaction with children. So again, this is something you're going to have to kind of figure out a little bit based on how your employees interact with the kids on your campus. They've tried to give us a little bit of help in coming up with this, saying that, you know, the common definition of the term should be used. Routine interaction should be considered based on what the employee's role is. So look at the employee's role, what their responsibilities are, and try to figure out, okay, in that role, would they have routine interaction with children? You might have someone who would normally have routine interaction, but because of their personality they do, in which case you might want to think about them differently. But generally you just want to think about what does this language mean and err on behalf of having the appearances done, because the interest of the children, child safety is the paramount concern. Yes. So the question is, what would happen if the employee refuses to do the background checks? Honestly, I think that would be grounds for termination. So I don't know if anybody feels differently, but yeah. So yes.
Now that these are on a renewal schedule, is that still in effect?
I think that is still in effect. That's a good question. I don't know if you know, Suzanne, but
yeah, my understanding is that it's still in effect. The ones that were out there, those are going to be for your new employees, and then for your renewals for those that can fill that out. Because I didn't see that as a piece of any of the documents, but that's also applied.
right.
Well, let me just say there's not a lot of clarification because it doesn't say that you don't when you're renewing. You got to get the payment for this.
Well, I think that's a question. I think that's a question. I think that's unclear whether they need to do it again. I think Suzanne's point is that you're asking for the same information, so you may want to renew that as well. But I don't think it's clear that that needs to be renewed every year. But these do have a renewal requirement. It's 3 years. But I don't think that that's necessarily the same. Sure. So the discussion is regarding mainly, there are clearances we need to do when we first hire someone. Those are the clearances that go through that long list of felonies and things that we can't hire someone based on. And so the question is, does that need to be renewed every year, or at least even on the same basis as Act 153? And no, it's not my understanding that it has to be, although I think that's a good question, and if I learn anything different after this, I'll let you know. But I think the point is that if you're doing it anyway, you may want to, just as a good practice, do that. So, sure.
Yeah, and I didn't think that they needed to do it every year, but they were asking every 3 years. So that's form. Since we're going to review the entire criminal background every 3 years, then I would anticipate that form would need to be filled out, although we don't know that for sure, every 3 years. Does that make sense? Can you hear me on that?
I have to say, in talking with schools too, I did actually find that some schools were already renewing clearances every 3 years or so, that they felt that was a good practice. Are most of you doing that now anyway, or no? Okay. I guess it's a wide, experience. Okay.
That's the one. We hired the people of that, and they were pictures of the last of those. They actually did the self-report.
Right.
So we took them to the lot in school, we like about hours, 2 hours. So that's the case, and supposedly we do our self-reporting, why would we have to need to form in addition to all those things that we have to do? So something's not in the brain, but that doesn't mean that it's kind of wrong.
So the question is, if they're already self-reporting within 72 hours as required, why do we need to do this, every 3 years? I honestly think that this is something that the legislature has implemented because they're concerned that people are not self-reporting, that there are too many people falling through the cracks. And so this is a way for them to say, we know that this is being done at least every 3 years. So, because you're right, every 72 hours, they should be self-reporting and you learn of these things. But I just don't know that that's happening. Right. Yes. So, Colleen, should I repeat that, or can people hear what the audience is saying? Okay, so just moving on, again, this is clearances, Act 153, so they must be submitted prior to an employee's commencement of employment. Employees may, yes? You assume that's not, so the question is, you have a different facility where you have requirements to do clearances under Department of Human Services requirements?
Yeah.
Well, let me just be clear. This doesn't replace any DHS requirements. So, okay. So, but you are doing these 3 clearances already. Then is that what you're saying? Okay. Mhm. You haven't been doing them if they were out-of-state employees? I think you would need to do them. Yeah, I would think you would. So go ahead. Mhm. Mhm.
I mean, I thought it was 2 years. So it was 2 years, the last 2 years we were trying to hire out.
Mhm.
Mhm. But is there a rule on that? Is it 1, 2, 3?
For someone who has their clearances for another state, are you trying to transfer the clearances in?
I'm hiring someone
Mhm.
coming in
Uh-huh.
and not living in the
Right.
last 12 months
Mhm.
or 4 months. But if they were told that I have to go first to not just Pennsylvania, but it's California, California.
Yeah, so the question is, if you hire someone from another state, do you have to redo their clearances, and do you have to do clearances from the other state?
So I'm going to use this place. That's
Uh-huh.
all that.
Yes.
How long it has to be. But if they can live in Pennsylvania for 4 years, why still need to go to other states if they have to do it?
Yeah,
Right.
Mhm.
But it's timely. I'm someone that has one year experience on me.
Mhm.
One that I'm getting from the qualified or not.
You know, I think it's a question I'll have to get back to you on. Act 153 doesn't speak to that, so I think under this you would just need to do the Pennsylvania one. So whether you have a continuing obligation and how long that is, I'm not sure in terms of another state's requirements. So let me get back to you on that. Yes. It might. I'm not sure what the other state check she's doing is. So do you know, Cindy, more specific? Mhm.
Right. Yes. And also, some of the really actually, something that should be aware of is back in the day, in the whole round, you cannot use cards, you have to use cards, nothing to do with it. Now, they've got better organized, but somebody who's a felon, they don't know about it. People move around all the time. Something people pick it up. And I just feel that it's really fun to do it in Texas, Europe, or even other places. So we find out what happens. It really takes 6 months to get to. But I think the question I know is, how does that change? Because the young students is right at the level. So what it says to us is that you're continuing background check, your FBI, your charges. That's it. If it's something else, you don't know.
Okay, so I'm going to repeat the question and summarize very briefly for those that are in the webinar audience, because they can't hear your discussion at all. They're getting some complaints about not being able to hear the participation. So the issue really comes down to this. So you hire somebody from out of state, and they've not lived in Pennsylvania for 5 years. They lived in California and Texas for those previous 4 years, and now they've lived, been here for a year. You have to do more than what Susan is getting ready. She hasn't even told you all the requirements yet, what she's getting ready to tell you. And so the response that we've heard, and that I agree would likely be the correct answer, first of all, is that these new regulations don't cover that. And the second point is that the FBI clearance that she's going to talk about picks up nationwide. And so there are going to be things that are going to be reported through the fingerprint check that are going to be picked up when your clearances are done. And third, more information to come as it is clarified by the state of Pennsylvania. Okay, so so that we make sure the two of us are going to tag team, I'm going to try to repeat your summaries when you do that, but Susan's going to then go back to the webinar. Great.
So does that clarify? This Act 153 doesn't change those requirements. So I don't think there's any difference now because of Act 153. You just have to do these clearances. Okay. Okay. Any other questions before we? Okay. So, oh yeah.
Okay. So the question is, at what age do we need to start checking individuals if we have children that are actually employed by the school and receive compensation? Okay, and so if they're 14, do we have to do a criminal background check and these other kinds of things on those young ages?
And I think, yes, you would need to do them. There's nothing I saw that would exempt it. So I would do the background checks if you're employing them, if you're paying them. So if they're not available, then you can't do it. I mean, it's not asking you to do something you can't do, but
So the point was by an audience member that there are juveniles and their records are not public. Okay, and I will tell you, this is not the only state that has done this. Several other states have required you to check on children that are under the age of 18, and they haven't eased those requirements, even though sometimes you can't get a record. And so you just have to show that you attempted, you weren't able to get something, and that then you're satisfied. Okay.
I feel like that satisfies your requirement, but I just feel that every other employee is going to take that.
And one school has said that's exactly what they do. They do it even on minors, and that when the record comes back, then it says no record because they're a minor. And so now you've satisfied your obligation until Pennsylvania clarifies. I mean, there are so many things that are open and unanswered. You just have to kind of work in that way.
And I'll tell you, too, that speaking with the departments, both Human Services and the Department of Education, I mean, they're working through these legislations. So I think these are good questions, and they're trying to grapple with them. I think, unfortunately, the way it works is legislators, our representatives come up with this great law, and then they need to implement it. So there are definitely a lot of ambiguities in the laws that we still need to work through. Okay, so these are the provisions of provisionally employing someone. You can have them do that for 90 days under certain conditions. Yeah. Oh, sure. Okay. So is there an actual form? Yes. So the question is there an actual form to use for number 3? And the answer is yes. Is that available on the website? Yeah. So the question is, can we give that form to them to fill out at the provisional stage? And yes, the answer is you can. Yeah, so that's the Act 24 form. Yeah.
Now, I'm in Thailand, so am I able to access the documents from the Department of Education? Because the legislature using the
Well, so the question is, can you access the forms on the Department of Education website? I mean, you can access them. They're definitely publicly available. Okay. Yes. Okay, so let me get to that slide that's coming up. So here's the deadlines for renewing clearances. So it's within 36 months of the most recent clearance. But just be aware there's kind of a little gap here that if your clearance is older than 36 months, then it must be done by December 31st. So you do have that leeway. But the issue too is if it's within the last 36 months, then you need to have them done as soon as possible. Oh, I'm sorry, I didn't repeat the question. So the question is, how often do the parents need to be done? Colleen, did you want to add to that? Okay. Okay. And then, so if they're prior to 36 months old, then you need to have them done right away because they need to be done within 36 months. So see, there's a little bit of a gap the legislature didn't really deal with. They gave us extra time for some people up to December 2015, but not for people prior to that period. So the question is, you're going to have someone who's not going to be there for more than 90 days, but you need to fulfill all of the provisional employment requirements, and one of those is that they don't work alone with children or in the immediate vicinity of children. So I would be very concerned in a camp situation because you could have them taking children to the bathroom or unsupervised. So I would recommend doing them anyway. I know there is that leeway, but I wouldn't.
I don't think there is that leeway. Number one. Which is that we have to actually have the
That's true.
agreement in order for you to get the 90 days.
You have to even have applied for it. So you can't get away with doing it all together. You can apply for it, and you cannot have them work with children, but you're not going to be able to avoid even applying for them if that was the question. A lot of questions. So this is another part of Act 153 that's been very tricky and I think controversial, which is that it also covers volunteers. So again, it covers volunteers who have direct contact with children. Direct contact, again, means providing care, supervision, guidance, or control of children. And volunteers must obtain clearances by July 1st of 2015. And again, those likewise must be updated every 36 months.
What about I asked this before, the stray parent field trip?
So the question is, what about the stray parent field trip? Well, I think you have to look again at whether they're having direct contact with children.
Children on the bus going to the meeting. I think that parents who go are supervising kids, that's why they're asked to go, a chaperone. Do they need to do this? It's one field trip, once in a blue moon. The public schools are requiring that, and my mom had to do the random field trip, and they do all this with public schools for years.
Yeah. Unfortunately, I think technically they would have to do that. I know it seems extreme for one field trip, but I think technically it would be covered.
And what happens if they don't?
Yeah. So the question is, what happens if they don't do that? Well, there are penalties in Act 153. Following a hearing, the department may assess a civil penalty not to exceed $2,500.
Is that per employee who's putting the fine, or is that as the school employee?
Yeah, and so so the question is that per penalty or is that against the school as a whole? And that's a really good question, Cindy. That's not clear. Yeah, I think it could be. I mean, if I had to interpret it, I think it could be per incident. So, but it's not clear. So. Yes.
Right. So the commentary is, for those on the web, that this is a sea change for schools because you haven't had to have these kinds of clearances like for your volunteers. I'm going to tell you it may be a sea change for some of you, but there are a lot of our clients who we've been advising for years and years and years that they should be regularly criminally background checking, fingerprint checking all volunteers that have any unsupervised access to children. So even though you might not have yourselves done it from an industry standard, this is really not an unusual concept.
Right.
Right.
What's really going to happen is that even on your drop off, you're going to ask, what am I doing for the law? I'm doing commands. I was today. Not only you guys are playing kids, but they know how to get the school. So we're going to have some of the teachers who absolutely cannot do it because the parents, because not included, cannot do it.
So the point is that you're not going to be able to grab somebody for the immediate need that the school might have to, hey, we need one more body on the field trip. Can you come and help us out today, Mrs. Jones? That you're going to have to make sure anybody you grab for those one-offs are on your cleared list, okay? And so I know, you may want to have a process, or a lot of schools do, where they will background check all the parents. Just think what information you could get. Woohoo!
So one option, and I think the public will do this, is at the beginning of the school year, everybody gets clear whether you're going on a field trip or not, and the remote possibility that you might possibly be doing something that's years down the line. But, I mean, again, what does that do to our community? We're an independent school, don't you trust us because our doors are open and we let our if I wanted it, I just my kids to public school. I can have an independent school. There's a reason why I never did independent school. So that's the cultural balance. And I'm willing to be one of the first people to do stuff, but this is something that we all have to do as a group or not. It's going to be hard for parents to do it.
So the comment is that this is really going to be a sea change at some schools, especially more independent schools, and there's the concern about the parent perception when they're told they have to do this. Yes.
Sorry, I don't know what question. My biggest problem is getting once I got a lot of things to do. That's all to do with how to do that. Because I don't have to do it. I don't have to say it. What I'm going to do is a vendor that anybody needs to come off school because they're really concerned with the single family. There's not a lot of reasons to do it. There's options. We don't like doing it, and how like hours, an hour here, and then 5 minutes here, then we have the skills to it. Really needs to require on all of the schools, we're talking to thousands of people, so that's what I think our biggest problem is one, getting a vendor that's going to come out and do things. I'm not complaining about the other two steps, because they're doing what one is done online, that's what we used to do. The second one is the child needs to do this. Magic law is in Harrisburg, and somehow these people come out and take it copies and what over on them, so it's reality that the single one is going to be the biggest issue. Because, again, the offices are only open certain hours, you may have your night open on some Saturdays, so if anybody's got vendors who do them, well, I think they're going to get out now, on the reserve for the fingerprints now. And he comes to your campus, he goes in certified, he will break it down into hours, he'll come right.
So the question is whether there's a vendor that would cover fingerprinting, and a vendor is being proposed by Cindy Nicole.
Oh yeah, you're getting that convenience. It's very expensive, but it's worth it if you're, he will give a break for an annual contract.
Cindy, you want to at least tell me the name and I'll repeat the name? Fingerprints Now is the vendor. Patrick Vessel.
Some of you may be able to work together to accomplish that as well. We'll kind of try to take a look at that if you're waiting both the vendors and the organization if possible.
Pays Boa is going to see if they can talk with and maybe negotiate something on behalf of the membership with Fingerprints Now, or some other vendor, recognizing obviously there's a great need. Were you going to add to that?
I was going to ask a clarification question. And I'm relatively new to education. And in my role when I came in, I went through a lot of all the files, right, through updating. And I found out that when the laws changed, and the requirements that there were a group who were allowed, if they chose not to say, I'm not going to do it, and they would be grandfathered in, right? So they weren't required to do it, and then I was warned before I did the email. Don't put our email out because we have the people who will be against my rights, blah, blah, blah. So I'm just trying to understand, has that changed with this law? That goes down and you can say, look, as of last December 31st, this is a requirement, and you have no records, so you've got to get this done by the end of the year.
Yes, so the question is for folks who were not required to do these clearances before under the prior law, do they now need to do them? And yes, they do. They specifically are addressed in the Act, and they need to do them by December 31st of 2015.
No, Could you send a link to the listserv? Yeah, I will. That'd be great. I'm actually looking for it.
Okay, the comment was, for those of you, that you can now do the child abuse check in Pennsylvania online, and they're going to provide the link to this website, to the listserv, so that everybody will be able to have that.
Now, is that the same, does that work the same as the criminal, or you get an immediate copy of the transfer, or is it mailed to you in the Philippines? Yeah, I think it still takes some of it. I just wanted to clarify that. I think it's not like the criminal where you get it right away and have it.
Okay, just to... All right, you guys, remember we've got an audience out there as well. So the point is that there's some question about how long it takes. You got to get registered. What I'm going to suggest is when the information comes out from the listserv, then you can, find all those details out. Okay, and I think, Colleen, you had a question.
So there's someone that just wanted to also suggest someone. She says, first contact HR is a good fingerprint vendor who will come on site. And she's named Leon Singletary, and I have that information.
Okay, so Colleen gave us another vendor that, will you put that on the PAYSBOA listserv, Colleen, that she's going to put on the PAYSBOA listserv with the information of the contact and the person's name and that type of thing that also does the fingerprints.
Okay, so I'll try to, I know our time is up. So the clearances required for volunteers are the same except the third one, the FBI one. It's not required if certain conditions are met. So your volunteers need to do the first two for sure, but the FBI one is not required if the position is unpaid, the volunteer has been a Pennsylvania resident for the last 10 years, the volunteer swears or affirms in writing that they're not disqualified from service, and copies, and actually that's it. So those are the three requirements for your volunteers to avoid that last check. Maintaining records, copies of the required information must be maintained by the school administrator, supervisor, or other person responsible for employment decisions. So you should try to put together some type of plan for where you're going to keep this and keep it in a confidential locked area. New hiring requirements, this is now Act 168. So what this is saying is that when we hire someone, when we have a job applicant come, they need to provide us with certain information. We need to then follow up on that information in a certain way. This is to address what the legislature called pass the trash, where people would not give any feedback on employees, so you'd never know that someone had an issue in the past. So I'm going to go through this really quickly, but let me just explain it generally because I think that will be easier. There's a form now that the Department of Education has on its website. I have copies of it if you need them. That's really the form you should get and follow because it will make this very easy. You give that form to your job applicants and they fill it out. And they need to fill it out for their current employer and every former employer. So that's so where it says job applicants are required to provide relevant contact information, that's on the form. They're required to provide written authorization to allow disclosure. Again, that's on the form. Yeah. Yeah, again, it's if it was a school entity or they're in a position where they had direct contact with children, then yes, they should tell you about it. And they should fill out a separate form for that entity so that you can send the form to that entity to get feedback. So again, this is the applicant requirements. Those are going to be right on the forms. Then it's the hiring school's requirement. What do they need to do? You need to then take the forms from the applicant and send them to the current employer and the prior employers to have them respond. And again, these are boxes right on the form that they can check off. Yes. Right. What the department has said is that if, so what if you have an out-of-state entity who you send the form to them and they just don't respond to you, they don't send it back. And what the department has said is that if you, as the hiring entity, send out the form, you've done your job. Then when you get back the forms, if you haven't received a form back from a certain employer, you need to use your judgment. It doesn't mean you can't hire the person, you just need to factor that in. So it's not something that will prohibit you from employing a person. Okay. So then, again, the hiring school is required to verify whether the applicant is eligible for employment, holds a valid certification, and has been the subject of professional discipline. You also need to inquire whether the Pennsylvania Department of Education has received notification of pending criminal charges. And this can all be done on the TIMS system. There's also a website that you can go to find this information. If they're not certificated, though, then they won't be on there. And the department has told me that if they're not on there, they're not on there. You've done your job by checking it. So you don't need to worry if they're not on there. They've said that you've done all you can by checking it. Yes. So the question is, if they don't require certification, do they still need to do that check? And yes, the department has said you still need to check that, but they're not. If they're not certified, they're not going to show up. So you've done what you're supposed to by checking the system, but they're not going to be surprised that for some employees you don't get any information. And they've said there's no other way for you to check. So you've done your job by doing that. Yes, Colleen? So the question is, applicants need to provide this information as part of the process, but we don't need to do anything with it until they're going to hire the person. So that raises a really interesting question because the applicants are now kind of in an odd position where they've had to provide information to you about their current employer, and you're supposed to contact the current employer to find out whether there are any issues. So you need to definitely do that before you hire them. Well, what we've been recommending, and I think I spoke with Pam about this, is that you put in your offer letter that I'm offering you employment, but it's conditioned upon getting proper responses to the background checks. And I think a lot of you might already have those in your letters, but you just really want to make sure of that, because if they come back with negative responses, you might decide not to hire the person. So you definitely need to do it, but you can wait until you're further along in the process so you're not notifying a current employee that, or employer that this person's looking with you. Okay, so then past employers, oh yes. Yes, so past employers are supposed to get back to you within 20 days. So they're supposed to give you those initial responses within 20 days. If you get a positive response to any of the questions, then there's a second form that you would then send to that prior employer or current employer asking for more information. And again, that's a form right on the Department of Education's website. I have copies if anybody would like one. So that would give you more information about what they've said is a positive response. So if they had some investigation, that's going to give you the background paperwork. Yes.
20 days is a long time. And if you do a conditional employment and they want to start 2 weeks from now, and they actually start working and if something comes back, we do something like that.
You can, there is a provision for provisional employment, but you need to deal with certain things as part of that, and I think one of those is that you cannot have them be alone with children. So I think you need to be careful, Nina, about, oh, sorry. The question is, can we employ the person provisionally while these are taking place? Do you have to have the original back? Which form are you talking about? Oh, I think you could get a copy. I don't see anything in the act that says it has to be the original. So I think if the former employer sends it back by email, that's fine. Yeah, so I think that's fine. Yeah. Yeah. It did already take effect, so yes, you should be. Yes.
Made hired for the spring semester who signed their letter, say, December 18th. Do they count as an existing employee, so we have a year to get them up to date on this stuff, or are they technically new?
So the question is, you have an employee who signed a letter of intent to start as of...
An appointment letter saying they're started January 1st, but the letter was signed December 18th. We had someone who was arguing to us that was an existing employee as of December 18th, even though they really started on payroll January 1st. I kind of don't like that. I would say they hadn't started.
We agree with you. That's a very unclear area. Our initial view is that if they haven't started, they're not an official employee.
I mean, you're not paying these individuals yet. You're not giving them benefits. They're not in access of children. You know, they're not supervising. And so I think that it might be an incorrect interpretation to say, hey, we're going to have everybody sign their contracts now so we can call them an existing employee by the time they actually start work. I think that you're far better considering them an applicant still for this purpose.
And one quick thing that's not in the slide but came up with one of our schools is just to keep in mind that when you now have a severance agreement with an employee, if you settle something, you have to be careful not to put a confidentiality provision or other types of provisions in there that will prohibit you from giving this information out because you're required to do so.
Did you guys understand that?
Okay. 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 So basically, sometimes you might have an employee that terminates with you, that you work out some type of arrangement where you pay them severance or something to try to, get a release. And as part of that process, often you'll have an agreement that they sign where they're releasing claims against the school and maybe you're making a payment to them. Just be careful. Sometimes we used to put in those agreements that everything was confidential. We wouldn't talk about it. They wouldn't talk about it. And you just have to be careful to make sure that you don't put anything in there that's going to prevent you from disclosing information about their termination. I mean, if you did an investigation and you found that they had abused a child or had done something that would need to be disclosed, you need to be able to disclose that to a future employer. You can't tie your own hands in some type of agreement. Yeah, the question is, what if they were student teachers or were not technically employees? I think technically the Act would not cover that situation, would not require
it. One thing that I think this discussion and the discussions that Susan and I have had with some of our other clients and in these processes is that there's a lot of clarification that's going to be coming down. The form itself has already changed a couple of times, the one that the Pennsylvania Department of Education has issued. So you're going to have to watch the forms. You're going to have to watch for updated information. We will bring updated information as there's some significant clarifications to PAYS BOA so that you'll get that. But this is an area where we can only tell you what's out there right now and give you a reasonable interpretation, but we can't necessarily tell you for sure that this is the way PDE is going to interpret it down the road, or that they're going to close the gaps on things that aren't closed yet.
Just to add to that too, actually I was talking to someone from PD yesterday and they said that today they should have responses to frequently asked questions on their website. So they're even still trying to work through this. I don't know that they're really going to be on there, but they're hoping to post them today.
I have a question about the definition that they should say of abuse. So abuse, so the kind of conduct that falls under the purview of reporting the environment. Then there's a series of digits and numbers that I think refer to the statute. I don't know what that means. Do you have any clarification on that?
The question is about the definition of abuse and what it means specifically in the statute. I think I'd have to look at it with you, Cindy, afterwards. I do have it with me, so I could go through it with you. But I don't know the exact section you're referencing. I don't want to tell you.
Her definition of it is not clear.
What's covered or?
Right. So we want. So the question was, what if the teacher was ever had a conversation about perhaps laying her hands on the student, or so it's not sexual abuse, it's a different kind of abuse. So you know, we can expose that to another
So the question is, you know, say that we have somebody that we've let go or that quit during the middle of an investigation of something that was not a sexual abuse, but it was a child abuse as under the normal statute. Is that disclosable? And I'll be honest with you, my response to that would be, I would say yes. Okay, abuse under the Pennsylvania statute is very broadly defined. And I don't think that the intent of this statute is to say we're only worried about sexual abuse, because that was the whole Penn State thing. I think it's really a much broader concept of any kind of inappropriate, wrongful type action, whether prosecuted or not, that occurred and was investigated that you did not find to be false. Okay.
I'm still stuck on the volunteer issue. At a small school, I'm going up to my parents and I all have to come in report. Can we get around that by just never having our volunteers alone with children? So we're usually go on a school trip and make sure we have 2 employees and one only goes with a parent and a child, so that they technically are never alone. Does that cover us?
I think it could. I mean, if you look at the definition, so the question is if you treat your volunteers in a certain way so as to not leave them alone with children or give them supervisory responsibility, could you then not have to do these clearances? And yes, I think that if they don't have those supervisory responsibilities, they're not alone with children, then they wouldn't be within that direct contact definition, and you could avoid this. But just be careful, because I think it's a broad definition, as Suzanne said, it's meant to cover. Right, so someone's pointing out that it even covers the possibility of interaction, which is very broad. It is.
Then just because you're supervised by somebody doesn't mean that you don't have direct contact. I mean, I think the word is direct contact, so I'm just questioning whether that's a fact. I don't know if it's accurate, but way to look at it.
Yeah. So one of the comments was, you know, really when we look at what the statute says is the possibility of having direct contact with children or supervising children or those types of things, or routine interaction with children. And you know, and so that it appears like, and I honestly have to agree, and you know, I think you need to think broadly about your volunteers. You know, say you think that you're going to have supervision, and that, so that this volunteer can't possibly do something. That's how you're interpreting it. You want to make sure the volunteer can't do something to the child. You know, there's all sorts of possibilities. You go to the restroom and a child happens to be in there. You didn't know there was a child in the restroom. I think if you have volunteers that are in places where children are, okay, that individual needs to, if they're there and they're kind of operating under your auspice, they need to be background checked.
I think we need to let it in that box, and then we can continue to conversation about it. If everybody will everybody on the
So yes, I can wrap up very quickly because this was actually the last slide, and it just indicates that those forms that I talked about are available on the website. So if you go to the PD website, you can get those 2 forms, and that's what you should be using for the 168 requirements. Thank you.
I wanted to emphasize something that Tina said, because you all are clearly, and I've heard this before, it's been ongoing, most concerned about I think the parent volunteers, and it does seem to me that it's a sense of consistency among all of you in practice, as opposed to something that's legislated like in the public schools. Makes a lot of sense because parents talk to each other, they have kids in various schools. Somebody decides to make an issue of it, and it'll be something you don't want to do damage control on because it's not worth it. If it's an important thing to do and it's required, sort of a uniform perspective about it, I think will be helpful to all of you, all of us. Just wanted to kind of make that point, and we'll see if we can't develop that to some extent through at least interchanges on the listserv like we've had today.